Welcome to Middle Class Matters Business News in English from Dr. CMA Allegation on the Securities Exchange Board of India SEBI confirmatory order on Subhash Chandra, the chairman, and Punit Goenka, the managing director of Zee Entertainment Enterprises Limited. Part number 12. The above letter of Yes Bank Limited makes a clear assertion that it was in possession of the LOC given by entity number 1, and post discussion with the leadership team of SL Group companies, it had proceeded to liquidate the fixed deposit. No future correspondences in this regard have been submitted by the entities to show that entity number 2, Zee Limited, had objected to the averment made by Yes Bank Limited in its letter. In any case, the measure that was taken by entity number 2, that is to strengthen the procedural requirement for investment or liquidating fixed deposit, is not sourced from where the situation discussed in the interim order has emanated. The primary reason leading to the interim order is the issuance of LOC to the banks for dues of companies related to promoters or promoter group, creating an encumbrance on the assets of a listed company. It is a matter of record that not only entity number 1 but also entity number 2 has issued the LOCs on multiple occasions. For instance, a LOC dated March 27, 2017 was issued by entity number 2 to RBL Bank Limited for the facility of INR 225 crore provided by the bank to Living Entertainment Enterprises Private Limited. Considering the above, I find that the measures taken by entity number 2 do not address the issues of encumbrances created on assets of Zee Limited, etc., which have been highlighted in the interim order. Further, the measure pertaining to the management auditor confirming the receipt of funds from borrower entities is incomplete, as has been detailed in the interim order as well as in this order. Moreover, the steps taken to invest only in liquid funds does not shield the assets of Zee Limited from the encumbrances, if any, which have been created on its assets for the benefit of companies related to promoters. In view of the above said discussion, it is clear that the measures that entity number 2 has taken are not oriented towards addressing the issues at hand, which is mainly about the corporate governance and adoption of robust controls while dealing with related parties on and off the books. From the minutes of the board meeting and audit committee meeting dated October 17, 2019, it is not clear whether the issuance of LOC by entity number 1 was brought to the notice of the board members or the audit committee members. Further, it is also not clear whether the letter dated October 11, 2019 of Yes Bank Limited, wherein it had referred to the LOC and had stated to have spoken to the leadership team of SL Group companies before liquidating the fixed deposit, was brought to the notice of board members or discussed in the board meeting. The only documented disclosure of the issuance of LOC by entity number 1 is in the annual report, which is much later in time. The entities have not submitted any material to show that the aforesaid fact was disclosed to the company or its shareholders prior to publication of annual report. Even after reading the legal opinion dated October 15, 2019, obtained by Zee Limited from external legal expert, it can be inferred that LOC and Yes Bank Limited letter dated October 11, 2019 were not disclosed to the legal expert before seeking the opinion on liquidation of fixed deposit by Yes Bank Limited. Entity number 2 in his submissions has not clarified whether the investigation which was carried out by Grant Thornton India LLP under the instructions of the Audit Committee of Zee Limited specifically dealt with the issue regarding the issuance of LOC by the promoters and the appropriation of fixed deposit by Yes Bank Limited, and whether it had examined the receipt of funds by Zee Limited from the associate entities. Upon perusal of the report submitted by Grant Thornton India LLP, it is noted that it dealt with film advances and related party transactions other than with subsidiaries exceeding INR 230 million. Without prejudice to the above, even if it is accepted for the time being that the transactions with associate entities were treated by Z Limited as well as Grant Thornton India LLP as related party transactions because of the criteria of INR 230 million, only dealings with two of the associate entities could have been examined, and that is also not clear whether it was examined. Thus, before any reliance can be placed on the aforesaid report, it is necessary to ascertain whether the report has examined the issue at hand. The same necessitates further investigation in the matter. In the light of the discussion above, it can be seen that when the entities were part of the management of Z Limited, the steps taken by entity number 2, Z Limited, were not relevant or adequate to address the issue at hand. Further, the legal opinion that was sought by Z Limited was prima facie without disclosing all the material facts related to the fixed deposit. Even the investigation which was ordered by Z Limited and the subsequent report made thereof is prima facie not complete in all respects. Thus, it is seen that entity number 2 was the MD and CEO of Z Limited at the relevant time, as well as till the passing of the interim order, is fundamentally conflicted and as prima facie not been diligent in taking steps to adequately address the issue at hand. This is not in the best interest of the company or its shareholders. He is prima facie involved in the scheme, which puts his interest in conflict with the interest of the company. Moreover, when Z Limited believed that the fixed deposit was misappropriated by Yes Bank Limited, then it is not clear from the available records or submissions why, in spite of the audit committee directing to take immediate action against Yes Bank Limited, Z Limited entered into a protracted discussion with Yes Bank Limited. It is not that both the actions are mutually exclusive. The same prima facie casts doubt on the exercise of independent judgment by entity number 2. Therefore, in the given facts and circumstances of the case, the measures taken by entity number 2 do not seem to be adequate and were not geared towards addressing the root cause of the problem. 42. As has been discussed in detail in the preceding paragraphs, the facts and circumstances prima facie show that a well-crafted scheme was orchestrated to conceal the default to Yes Bank Limited by the associate entities of the SL Group and to conceal the fact that the funds that were owed by the 7 associate entities to Z Limited were actually not paid, and only a false impression was given that the 6 associate entities from their own sources had made good the loss that was caused to Z Limited on account of the appropriation of the fixed deposit of INR 200 crore by Yes Bank Limited under the LOC issued by entity number 1 during the tenure of entity number 2, and both the entities being part of the promoter group and beneficiary of the associate entities. 43. With reference to the submission of the entities that the burden of proof has not been discharged by SEBI, as there is no evidence to establish that the impunged fund transactions or bogus transactions, I note that the interim order has unequivocally brought out that the fund transactions were layered and circular in nature and were carried out amongst companies or body corporates of the SL Group. Further, the transactions were executed within very short intervals over a span of couple of days, and that this pattern was executed not just in 1 or 2 cases but in as many as 6 cases. The possibility of this being a coincidence is too low to be leniently considered. Thus, the opposite circumstances or on a preponderance of probability basis show that the fund transactions were prima facie non-genuine. Hence, the submissions of the entities in this regard are untenable. Role of entities. 44. While the elaborate discussion in the preceding paragraphs brings out the role played by entity number 1 and entity number 2 in the scheme, I find it appropriate to, in summary, delineate my findings in respect of the role played by them in the whole scheme. 45. Entity number 1 had issued the LOC to Yes Bank Limited on September 4, 2018 for the amount of INR 200 crore, which prima facie is the root cause for the designing of the alleged scheme. By the next day, a fixed deposit of INR 200 crore was created by Z Limited. As has been prima facie held in preceding paragraphs, the said LOC cannot be considered as having been issued by entity number 1 in his personal capacity. At the time when the fixed deposit was created and when the fixed deposit was appropriated by Yes Bank Limited in July 2019, entity number 1 was the non-executive director of Z Limited and the chairman of Z Limited and SL Group. Upon appropriation, he neither took any concrete corrective steps nor brought the fact of appropriation to the notice of Board of Directors of Z Limited. Yes Bank Limited, in its letter dated October 11, 2019, with respect to the appropriation of the fixed deposit, has made a reference to the LOC issued by entity number 1 and had also stated that it had discussed with the leadership team of SL Group various possibilities, including appropriation of the fixed deposit towards the dues of the associate entities. Thus, prima facie, not only the LOC given by entity number 1 gave Yes Bank Limited the comfort to liquidate the fixed deposit, but Yes Bank Limited actually did so with the knowledge of Z Limited's leadership. Entity number 1 has been leading the SL Group for more than 30 years. He was a part of the board of Z Limited during the period when the entire scheme was designed and implemented. It has already been detailed in earlier paragraphs that various companies or body corporates belonging to SL Group were involved in obscuring the fund trial of the impinged transactions. The said companies or body corporates, being private limited companies and LLPs, and the facts that majority shareholding in them was held by entity number 1's wives, son, and other family members, prima facie shows that entity number 1 had considerable control, influence over them. Further, it was during his tenure on the board of Z Limited that the financials of Z Limited was misrepresented and the wrong announcements were made to the stock exchanges, as has been brought out in the interim order. In view of the above said, it can be prima facie inferred that entity number 1 was not only involved from the very beginning, but looking at the companies or body corporates involved in this scheme and the similar pattern of fund flow across 6 different chains which have been described earlier. Considering the above, I have no option but to conclude that entity number 1 was actively involved in the design and the execution of the scheme, which has been found prima facie to be in violation of the securities law. Please like the video, subscribe to the channel, and share to your friends to disseminate the knowledge on corporate workings, so that we will be careful while investing in the companies. Thanks for watching.